And I got to tell you, once you start sending for evaluations and counseling, first off, you're talking about the cost of the litigation skyrocketing. And if you're not allowing the public to see what's going on in the courtroom, I don't believe that's right. I call it the touchy-feely phase. Let's all hug, kiss, and sing kumbaya in these family court cases. I'm sorry, that doesn't work. I will always put families first.
Welcome, everybody, to our Nevada Judges Election Interviews. And I'm John Stiles. To my left is defense attorney Mr. Ben Bateman.
Yes.
And our guest today is Judge Paul Gaudet. And Judge, you are the judge for the Family Court Department in Clark County, right?
That is correct.
Okay. I always start out by asking this question. What is it about being a judge that you like?
Well, I've been on the bench for about 14 months now. I was appointed in March of 2023, so I guess that's quite a while.
It is for me.
The reason why I'd like to be retained, multifaceted. First off, I enjoy what I do. It's much different. As an attorney, you're an advocate. As a judge, you're an arbiter. And I have enjoyed listening to the positions of the parties and the attorneys and making decisions. I enjoy very hard thing to do, but I enjoy making decisions. The second reason why I'd like to be retained is I'm proud. I'm proud of what I've done in 13, 14, 15, I guess 14 months on the bench now. The number of families that I've been able to move through the system, the justice that I've handed out. I think I've done a pretty good job. I've made the department as efficient as I possibly can, and with that efficiency, I think I'm going to put it to you this way: I'm proud of the fact that I believe Clark County's getting a bang for its buck having me on the bench.
What's been obviously, being an attorney, you have the notion, gosh, if I was a judge, I would do it this way or whatever. And then you get to be a judge, and then I'm sure some of those notions were the biggest notion that's been.
The biggest adjustment as an attorney in private practice, you have clients, and I was fortunate. I practiced here in town for over 30 years. I had really good clients, okay? Now looking back at it, I had really good clients, okay? But I had really good clients. When I was appointed, what I did was I went into the office about a week early for a couple of reasons. I wanted to get familiar with the computer system, the interplay between the different systems, but I also wanted to prepare to get on the bench that first week. And I'll never forget this. I brought in my staff. I made a decision. I think it was a pretty good decision. I tried to keep the existing staff. I thought that would make it the transition a little better. In retrospect, it was a good decision. But I'll never forget asking the question. My JEA, I said, the question was, what percentage of the cases that we have do you think are pro per, self-represented, people representing themselves? And he sat there, and I'm thinking 55 to 60% of the cases. And he said, Judge, I think it's 70%. I said, come on, 70%?
Really?
And I got to tell you, after being on the bench for over the year that I have, it may be 75%. So that was the biggest. That has been the biggest adjustment. Look, I tried several hundred cases in my career. When it came to putting on cases, I can hit the ground running. I'm very experienced in doing that. I guess you take the bench thinking you're going to hear these eloquent arguments by the attorneys, and you're going to decide. Right. And the overwhelming majority of the cases that appear before us are people representing themselves. Quite often, one side representing themselves, and I'm telling you, just as often anymore, both sides representing themselves. So the hardest transition has been. My job right now is a judge. I'm not an advocate, and I tell them that. So you're free to represent yourself, but you have to follow rules. More importantly, when it comes to me taking evidence to be able to make a best interest determination on the part of a child, one of the things that you have to adjust to as a judge is, how far do I go? I'm not their attorney, okay? But by the same token, I want to hear the relevant testimony. I want to see the relevant evidence for me to be able to make a good, fair, reasoned best interest determination. So honestly, that's been the biggest adjustment. You go from practicing law for 30 years where, let's just hypothetically say 85-90% of the time you have a qualified attorney on the other side, to a situation where 65 to 70% of the time you have a self-represented person appearing before you. It's a different beast. It really is.
So what challenges then does that present to you as a judge then to be impartial to someone that maybe doesn't know what the heck they're doing in court?
Well, what I've tried to do is we create little we've created little processes. We try in family court. Many of the issues we resolved are fact-based, factor-based. So if I can let the litigants know what the factors are that I have to consider. In a best interest determination, I have to consider these factors. In a relocation case, I have to consider these factors. In a modification case, in child support, I have to consider these factors. And if I make them aware of what the factors are, but I'm going to tell you how I do it, and I got to tell you, I think it's working pretty good. I really believe the self-represented need to feel a couple of things. They need to feel, first off, that they're being heard. They need to be given their day in court, and they need to tell their story. So what I do in these cases, and some of the staff sort of chuckle, but I do it in just about all the cases. I call the case, I say, good morning, thank you for appearing. I understand you're representing yourself. When I typically, in these cases, I swear them in, I don't have them take the stand, but I ask them two questions. I say, this is your chance to tell me what it is you want me to do, and more importantly, this is your chance to tell me why I should do what it is you want me to do. And I kind of open the door for them. And then if they need help, I always, why don't you tell me your name and your address? I try to make them feel as comfortable as I can. And then we get it moving from there. And you'd be surprised. People going through the family court system need to tell their story. And I think we get to the point where we think these stories need to take 2 days to be told. That's not the situation. They want to come in on their own. They want to take 10, 15, 20 minutes to tell me what's going on in their lives, what's going on in the lives of the children. And then once I make a decision based upon that, they're okay with it. The people that have a problem are the ones that feel like they weren't being heard. Big adjustment, though. You go from dealing with attorneys to dealing with non-attorneys.
Well, and in the family court system, the people that you're dealing with, this is an extremely emotional, life-changing impact on everything that happens, your decisions. And not only the mother, the father, you have children involved, so you have to consider all of those different aspects.
Absolutely.
That's got to be tougher than a justice court or municipal court or...
I'm going to be honest with you. I tried personal injury jury trials. I tried criminal jury trials. I tried real estate bench trials and jury trials. And I tried hundreds and hundreds of family court cases as an attorney. And I'm not knocking anybody doing any other job. Okay, these family court judge jobs are very, very difficult jobs for a number of reasons. First off, we don't do jury trials. Not only am I putting on the proceeding, I ultimately have to find the facts.
Right.
Okay. So I am the fact finder. I apply the facts to the law and I make the decisions. I'm telling you, this is not a job cut out for someone that is not willing to make a decision. As a judge, if you hem and haw between these people, you will keep them in this system for an unnecessary amount of time. Trust Paul on this. Trust Judge Gaudet on this. The longer you keep people in this system, the more the emotions fester and the worse the case gets. Okay?
Exactly.
So look, I enjoy it. I'm fortunate. Stress is ever since I was a young attorney, man, stress just doesn't bother me. I'm like a duck. It flows right off me. So the stress associated with, God gifted me with an ability. When I walked out of my office for 31 years as a practicing attorney, I left what was going on in the office. He also blessed me with the ability for the last 13, 14 months. When I walk out of that courthouse, I leave what's going on in that courthouse behind me. Does that mean there's times at night that I don't wake up thinking about a decision? No, of course that happens. But so the answer to your question is, yeah, I agree with everything you said. This is not an easy job by any stretch of the imagination.
It's not easy for the people either.
Well,
I like what you had to say about getting them out of there.
Oh man, you got to get them out of there. Look, I developed a little different mentality, and it's something that I didn't care for. Our system, you got to remember, we are still a judicial system. Okay, the rules of evidence should apply. Statutory authority should apply. I think we went through a phase, and it started I started practicing law in 1992. It sort of started around that time, just after that. I call it the touchy-feely phase. Let's all hug, kiss, and sing Kumbaya in these family court cases. I'm sorry, that doesn't work. Okay, that doesn't work because the longer you try to get to, there's a reason these people are before us. They don't get along. Their relationship has ended for whatever reason, and now they have to go on with life. What I try to do is I try to make them aware that they were a family. And separation, divorce doesn't mean they're not still going to be a family. It just means the family is going to grow in a different direction. Okay, and if we can get them out of that system with as efficiently and expeditiously as possible, with them believing that their position has been heard, the decision that I make, I like to use the word palatable. Okay, it's much more palatable. They can leave court and they can live with the decision. When they're in that system for a year and a half, I made a conscious decision. I would not use valuators. Okay, I am the district court judge that was appointed. I am the family court judge. The ultimate decision-making responsibility falls upon me. I think we've developed a different mentality in the system. Let's send them for an evaluation. Let's send them to counseling. And I got to tell you, once you start sending for evaluations and counseling, first off, you're talking about the cost of the litigation skyrocketing, which causes even more stress in the life of these parents, okay? But you're talking about a time frame. I'm gonna give you an example. When I have a custody case that comes before me, I can typically give an evidentiary hearing date within a period of 90 to 115 days, okay? I know that sounds like a long time. That's pretty quick to get you a trial date, okay? So I move on. If I start sending for evaluators, you're talking minimum 5 to 6 months before and in some cases much longer, before you even have the evaluation back. And I'm the kind of guy, when I do that and they pay the cost, I don't just take what the evaluator says as gospel. I actually look at the fact. So if I'm going to be looking at the facts of the case, why not just have them come in and tell me their story, where I can ultimately make the decision, because ultimately that's my responsibility to make the decision.
And the results that you get from that is not necessarily in the best interest of all those people involved.
Yeah. In a custody case, the sole consideration of court is the best interest of the child.
Right.
Okay. But as a judge, I'm always dealing with the best interest of the family.
As a whole.
Now, the law says it's the best interest of the child. Yeah.
Right.
But when you make as a judge, when I make a determination that I believe is in the best interest of the child, I think incumbent is taking into account the best interest of the parents also, because there has to be some harmony when I send them out of court. I don't know if you guys looked at it. We have a small percentage of these cases. I would say it's probably under 10%. Maybe 5%, but it's a small percentage of the cases that we refer to as high conflict cases. I have cases before me, I've only been on the bench 14 months. I have families that have been in this system for 14, 15 years.
Jesus.
And they just keep coming back. Now that's a small percentage of the cases, but that does exist.
But still.
Yeah, so I think if I, as the judge, can evaluate the facts of the case, I mean, I'm not going to I don't have a magic wand. I'm not going to do away with high conflict cases, but I think if I give the parents, the litigants, the opportunity to state their positions in court, make a decision, and explain why I'm making the decision. Once again, I get back to that word palatable. Right. They can live with it at that point. So that's my philosophy on resolving child disputes.
You mentioned in your introduction that you made things more efficient in your department. What did you do? Is there anything that you can speak to specifically?
Yeah, there's a couple of things. I mean, I did this for 30 years, so I tell people I was before enough judges where I think I saw characteristics that made what I believed was a good judge, and I saw characteristics that I believe I don't want to call it
not so
bad
good.
Not so good, Judge. That's a better way to put it. But I just adopted certain philosophies. Referrals. Okay. Judge Gaudet refers very few people out. Look, if you guys want to go participate in counseling and you do it by stipulation, who the heck am I to say that's not the right thing to do? But if I have one side asking for that, when I take into account the cost involved and the good to come from it, come in court, let me put you on the stand, swear you in, I'll hear the testimony, I'll make a decision. I don't do a lot of returns. I am not a counselor. Okay, I'm not a family counselor. I'm a darn judge.
Right.
Okay, so a lot of and it still goes on, but I saw this for years. You go in, you have a 15-minute hearing, you set it for a 30, 45-day review to see how things are going. You go back in, they set it for a 30, 45-minute review to see how. Well, first thing, that clogs my calendar like you wouldn't believe.
Right.
It takes away attention that I should be giving to new filings, things that I need to move through the system. So I developed my philosophy when I took this position was I would not refer a lot of things out, and I will not set things for repetitive conferences to review what's going on. That's not my job. Look, I give you an order. You guys go out there and live your lives. If something goes wrong, these things are always subject to review and modification. And if something goes wrong, there's no doubt in my mind the parties and their attorneys are competent enough to get the issue back to my attention. I'm not a counselor. I can't meet with you. Trust me, I have thousands of cases assigned to me, okay? If I get to the point where I start setting things for review to see how things are going, these people need in my opinion, they need finality. They don't need continuing return. But by the way, if I set 4 45-day reviews, I've just kept them in the court system probably 6 months longer than I should have, in my opinion. Okay, so you asked, yeah, that's some of the things that I saw while I was practicing that led me to the philosophy that I apply being on the bench.
Without naming names or giving away too much information, do you have one case that sticks out in your mind that you go, that was the best decision I've ever made?
Yeah, and of course I can't name names.
No. I wouldn't expect you to. I don't want you to.
I had a case that came before me very early on. It involved custody of a child. It involved abuse. And there was no response from the father. And I saw service issues right away. So I denied the motion, but I specifically referred to the abuse order that had been entered out of California. Okay, and I brought the case back. I denied the motion. Motion was sub. Long story short, I got these people in. Let's see, I took the bench. This was probably the first or second week I took the bench. This would be March of 2023. I think February of this year they returned on a thing. And it's one case where I sat the parties down, young parents. I sat the parties down and I explained what I thought their responsibility as parents were, what I thought their responsibilities as litigants were, and we have gone through a scenario where I think I got through to both of these parents. The last time they appeared before me in court, they actually thanked me. And I'm not talking just the mom, just the dad.
Yeah.
They both thanked me. They both indicated to me that they had listened to what I had said. They took to heart what I had to say. And I think now this little girl that's probably, if I remember right, she's like 4 years old. I think she stands to have a much brighter next 14 years of her life than she had before they came before me in March of 2023. But yeah, I could tell you a bunch of them. Look, the decisions that we make are very, very tough decisions, okay? So if I told you for 1 second, I don't question my decision after that's natural with what we deal with. We deal with some situations. There are two types of cases. The answer to your question has more to do with types of cases than facts of the case. I'm going to give you an example. Two types of cases that are extremely difficult to deal with, okay? Our termination of parental rights is been referred to as the civil death penalty by the Supreme Court. And the second type of cases that are really difficult for me as a judge are relocation cases, particularly when I'm dealing with two really good parents. I have two good parents here in Nevada. One of them wants to move to Florida. Those are the tough cases because regardless of the decision that I make in that case, this child is going to go extensive period of time without seeing one of those parents.
Yeah.
Okay. And then the termination cases are tough. Now you have some termination cases where you're just dealing with, and I hate to say that, you're just dealing with really bad parents. People who have shown no incentive to be a parent. Those aren't that hard. You have some that are much closer calls, and those are tough cases. I'll tell you another one.
All right.
Please.
I'll tell you another. I think
This is your time to shine.
I think it was the first day I took the bench. I had a fellow appear before me, another judge, whoever was on the bench before me, had entered a decision with regards to child support, and this case was still set for trial. And this fellow had not paid child support. He just refused to pay, and he was a former military vet. And I got him before me, and I think his attorney really appreciated this too. And I thanked him for his service. I said, on behalf of myself, my family, and I hope Clark County, I thank you for serving. But I explained to him that even if he disagreed with an order, I would require him to follow the order. And I used analogies to the battlefield, chaos that would occur if you didn't follow orders. I asked him a series of questions. And I said, look, this is what I'm going to do. I have the power to hold you in contempt. And I want you to understand, if I hold you in contempt, I will put you in jail for non-payment of child support. It's not what I want to do. I want you to be a good, productive father to your kid. You can get one chance, one last chance, okay? This was before we had like a trial date, or we had a calendar call date set where we were going to set the trial. And I said, if you have it current at that time, you will purge your contempt. If not, I'm putting you in jail. And as they were walking out, the attorney actually turned around. I could see, and within a matter of days, he had paid. So that was. I think I did. I'm proud of myself for the job I did explaining to him his obligation and his requirement to follow the law. And I think it helped. But we see those kinds of cases all the time. So.
If you had a magic wand, could change anything about the family court
I
system.
use that all the time on the bench. If I had a magic wand.
Well, what would you change that if I don't know, the way cases are assigned, or I don't know, anything that maybe frustrates you that you would
I think,
change?
Of course, I don't have a magic wand. I think it's way before the court system. I think what I've seen, I saw this for 30 years, though. We have as a society, we have sort of lost focus on family, okay? We have a lot of people, for whatever reason, having children that probably aren't mature enough, educated enough, responsible enough to have children. And that's a problem. If you're going to bring a little baby into this world, you have to acknowledge your responsibility to take care of that child. And I see too many we see some really, really bad cases where people just do not understand their obligations and are willing to accept their obligations in having a child. How do we change that in society? I don't know. If I had a magic wand, I'd wave the magic wand and I would reinstill family values all over the place. Now, when it comes to a magic wand with regards to the court system itself, I think people forget, I'm on the campaign trail. I'm asked questions. There are several groups that ask questions. I feel like I'm being required to justify the existence of the system, the family court system. I'm one of 26, okay? I run my department a certain way. You can ask me questions about my department. I'll answer questions all day long about my department. I'm not here to justify what anybody else does. That's not my job. I'm here to justify what it is I do. And, I tell people all the time, I think I've been told quite a few, I run my court pretty well. Come sit in my courtroom and see what I do. I'll give you an example. My brothers back home, they came out for the investiture, and they, for 30 years, they knew I was an attorney. They didn't know what I did. They didn't know I tried murder cases. They just know I'm an attorney. So I become a judge. And I forget what day the investiture was, but it might have been when my daughter was married. They'd come back into town. But, what kind of stuff do you do? What kind of stuff do you... I don't know how to explain it to you. Why don't you come sit in court and see what I do? So they come sit for, I think it was a morning calendar. I had a couple of my nephews. After 4 hours, we leave, we go to lunch. I go, my God, this is like really serious. You actually control people's lives. Yeah. That's the kind of, so you point out, I had a good buddy of mine from Seattle. He's the same thing. He's one of my dear friends. He came into town. Well, what is it that you do? Well, Greg, come sit in the courtroom. He came sit on an afternoon calendar. We drive back he gets on the phone with his wife, and he says, Gail, the problems I thought we have no problems with it. It's how do you describe? You'd have to come sit in and see what's going on, but you'd also have to sit in each individual department to see how things are handled. Because once a case is assigned to an individual department, barring being taken off the case for some reason, barring that becomes that department's case. And you can see how the case is handled department by department. I'm not saying I'm not that pompous to say I'm right 100% of the time, but I will tell you I run my courtroom, I run my department in a pretty efficient fashion, and you're more than welcome to come out and see how I run the department.
You know, along that line, since you went down that road, you were pretty instrumental or led the charge in our Nevada judges being allowed in the courtroom to film in the family court system. What that tells me as just a layperson is that you are confident in what you're doing. You're not afraid to be transparent, and you think that that's the way it should be. Period.
I'm going to tell you a story, and this has got no. I remember this vividly. My office was on 4th Street when the statute came down. The divorce statute came down saying, and I'm paraphrasing the statute, but any person can seal a file for any reason, blah blah blah. I remember getting a notice, and I wasn't in a partnership. We're partners in the bill. I practiced with the same gentleman, very well-known attorney here in the state of Nevada for 25 years. And I remember having the discussion with him. The statute's not right. The statute's not right. You impose the statute, you're creating, the public has to trust that what goes on in that courtroom is right. Okay? And if you're not allowing the public to see what's going on in the courtroom, I don't believe that's right. People talk about, and I understand we deal with child issues, okay? And that's very touchy issues,
right.
Okay? But I'm going to give you an example. If I'm dealing with a case in my courtroom that involves financial issues, okay? I can understand why they would want that case sealed. But what about the guy in the criminal court who's wrongfully charged with committing wrongful sexual acts against a minor? What is the justification for opening that? So look, I think the one judge's opinion. Sure. I'm one of 26. Right. I think our Supreme Court hit this one on the head. Okay, and I'm not necessarily talking about the unconstitutionality of the statute and the rules. I think the Supreme Court hit it on the head. It should be a case-by-case determination made by the judge. You are giving me discretion to make a determination based upon the facts of this particular case on whether or not that matter, in the our Nevada judges, the media should be excluded from the courtroom. Right. And I think it does. I don't know. I think too many people. And I'm one guy. I think too many people are looking at it as a knock against the system, potential harm to the system. I look at it as benefit to the system. If you come into my courtroom and you see what it is I do, you're going to do one of two things. You're going to say, hey, that Gaudet guy, he does it pretty damn good. Or you're going to say, that Gaudet guy, he's a whack. But I'm confident enough in my knowledge, in my ability, and I'm confident enough in the way I conduct my courtroom to allow people to come in and see and see what's going on. Now, once again, when there's an objection, I will review every objection. I will consider the facts presented. I will apply the law that the Supreme Court has told me I need to apply in making a determination as to whether or not the media is going to be in my courtroom, and I'm going to make a decision based upon my discretion to say yes or no.
And personal opinion is, I think that's how it should be. Yeah. There are situations where you know best. You're the one that's familiar with the case. You know what's involved in it. So I don't know. It is kind of a double-edged sword too.
The child cases. I mean, look, when you got a child out there, how much of this do you want? The child cases are a tough one. The finance cases. I mean, I understand why you don't want your finances made, but why you don't want things going on in your personal life made public. But by the same token, think about that before you start filing suits and motions and making allegations. Yeah. And maybe sit down in a reasonable fashion and get, if you come to my courtroom, you'll see I tell people all the time, the attorneys don't. But I'm being sincere. A lot of this is not rocket science. Okay, division of property and debts. There's always 100 ways to skin the cat, and I understand that. But what our law provides, and it wasn't like this when I started practicing, but what it provides now is equal. Okay, doesn't mean we got to sell everything and liquidate it, but when we come to the end of the ledger, the husband's side should equal the wife's side. Okay, what these cases require is transparency between the parties, disclosure between the parties, and honesty between the parties. Because when you're transparent, you disclose, and you're honest, with the assistance of a qualified judge and 2 competent attorneys, you see why I say this isn't rocket science? Let's just sit down and get it done, okay? And maybe if a high asset value couple realizes that, hey, our private business could be made public, maybe they come to their senses and they sit down in behind closed door, and resolve this. But I'm a proponent of the court system being transparent. Well, my name is Paul Gaudet. I'm your judge in Department N of the Family Court. Governor Lombardo appointed me in March of 2023. I've now been on the bench for about 14 or 15 months. I was a 30-year practicing attorney, just over 30-year practicing attorney, before I was appointed as your district court judge. I had a lot of trial experience before I took the bench. I have a lot of trial experience since I've taken the bench. I've put on a lot of cases. I'll make you a couple of promises. I will always put families first. I believe that's very, very important. We sort of discussed that a couple of minutes ago. I think people fail to recognize divorce and separation does not mean that a family ends. It means that a family may be separate, but that family is going to continue to grow in the future. And I think that needs to really be taken into consideration when a judge makes a decision, particularly in child custody cases. My website is Gaudet, Gaudet, my name, for spelled out FOR, judge. That's Gaudet4judge.com. My information about me personally, me professionally, my career, my education is available on the website. More importantly, and this is, we get back to transparency, you will find an email address for me on there, you will find a phone number for me on there, and you will find social media. If you have any questions, reach out with those questions. I want to be transparent. I can't answer factually specific questions, but I can answer questions on my philosophy pertaining to different issues. And I encourage people, look, I'm a judge and I'm very, very busy. I can't tell you you're going to get a response to an email in 10 minutes, but trust me, you will get a response to the email, and it will be a response from me. It won't be a response from staff, campaign managers, or anything like that. It will be a response from the judge. The thing that I want to be proud in what I do as a judge. Just as importantly, I want the community to be proud of what it is I do as a judge. And I made that commitment. Well, first off, I'm gonna work as hard as I possibly can. I'm gonna be as prepared as I possibly can. I'm not gonna let you guys sit in this system for extended periods of time. I will make decisions and move you through the system as efficiently as I possibly can. That's my promise to you. Can I say one other thing?
You can say anything you want.
I'm a district court judge. A lot of people don't understand the court system layout in the state and the county. I am a Clark County District Court judge. I get asked all the time, can I vote for you? The entirety of Clark County has the opportunity to vote for district court judge. You will not see my name on the ballot in June. I drew only one opponent, so that means we go through to what they call the general election in November. So simply because you don't see my name on the ballot in June, please don't forget about me. The name will be on the ballot in November.
Great. Well, thank you. Thank you for coming in.
I appreciate your time.
Yeah.
Thanks. It was nice
Ben,
meeting you.
thank you too, man.
Yeah, no problem.
Judge, thank you.
Nice meeting you.
Before we go, I just want to say one thing, and I say it every time. The people at the bottom of the ballot, that just besides the president and the vice president and your senators, these people are more important to you and your everyday life than anybody else. Your school district, your city council, the judges, these are the people that have the greatest impact on your everyday life. Please vote the entire ballot. Vote.
Can I add a note to that?
Please do.
I know I'm a numbers guy. Numbers never lie. 2020 election, there was a 26% drop off from presidential votes cast to the district court family. 26% of the people that voted on the first line did not vote for district court judges in the family division.
And that's one of the reasons that we're doing this.
The numbers don't lie.
Right.
All right.
Thank you all.